Florida Supreme Court's case law, I'd ask the court to reverse.
All right, thank you, sir. All right, the court will next address the case of Jefferson versus State. I got 4 minutes on the clock now because that's
If I could
what
have three.
Mr. Pono wants. What do you want, three?
Three, yep.
A rebuttal? All right, sir, we're ready to go. Fire away.
All right. Good morning. My name is Ed Weiss. I'm here on behalf of the appellant, Mr. Eric Jefferson. We're here. Mr. Jefferson was charged and convicted of ag manslaughter of a child and was sentenced to 13 years in prison. There are two issues raised on appeal. I would like to address mainly the first one, but if there is time, I would like to address the second one. In Arnold, the court expressed a concern that these cases can become strict liability if appellate courts don't adhere to strict compliance with the evidentiary rule. What this case represents is not just the fear of the Arnold court, but a further fear and a perversion of due process in our states. It expresses how a defendant is guilty until proven innocent, as testified to multiple times by Dr. Talleli. He testified multiple times. Unless I'm told of a history, a person, it is always, not sometimes, always the result of a sole caregiver alone with the child for a period of time. That is not the standard of proof in a criminal case. When we look at this case, there was alternative theories. Manslaughter by act. First off, this was preserved. Trial counsel specifically argued the state failed to prove that my client did any of these acts. And that was conceded throughout the trial by the state. The state many times in closing said, we would be here on a first-degree murder if we knew who did this. I can't sit here and tell you who committed which acts or which this. I would be misrepresenting to you if I said he did this or that. Manslaughter by act was not proven in this case. That was preserved. Admittedly, trial counsel did not move for a judgment of acquittal on the manslaughter by culpable negligence. However, as FB and Tibbs all state, if there's insufficient evidence of a crime, then that's fundamental error. When you look at this case, the state below and on appeal has done the same thing. They emphasize the injuries to the child. Injuries to the child is relevant for the manslaughter by act, and it is to a certain extent relevant for the manslaughter by culpable negligence. But there is one failing that was never done below and never done on appeal. There is not a shred of evidence in this case that this child died as a result of failure to get aid. There is no testimony that this head injury, which is clearly the only injury that resulted in her death, was worsened by the delay to get aid. There is no testimony that this child would have lived but for the delay in getting her help. In fact, I argue that the injury to the head was fatal no matter when help was gotten. You had necrosis of the brain. That's not something that's going to take lightly. Now, granted, I'm not a doctor. I don't know anything, but that's just it. There were doctors, and there's no testimony that this child could have survived that head injury. And that is what would have been necessary for the state to prove the aggravated manslaughter of a child. Their own testimony, their own evidence is contradictory of itself. You had some doctors, and I believe the medical examiner said this could have occurred several days before. Then you had Dr. Talleli say, oh, no, she would have immediately been unconscious and seizing. This happened within 24 hours. The state's theory about the text messages, which occurred 2 days before 911 was called, is completely contradicted by Dr. Talleli's testimony. Even with those texts, there's no context to those texts. We have no idea what they're in reference to. The state is inferring they're referencing the injury without any evidentiary support. When you look at the doctor's testimony of what they would have expected the child to behave like, that is all guesswork. Under their own theory, this child should have been showing signs of injury when she was being watched by her grandfather 2 weeks earlier. But what did Grandpa say? She was fine. She was normal. She wasn't nauseated. She wasn't vomiting. She was eating fine. Completely contradictory to what Dr. Talleli and the medical examiner testified to. The actual testimony of the behavior of the child contradicted the expert testimony. Just as in Rodriguez versus Pino, where the third DCA said that expert testimony cannot be considered, the same should apply in this. When it boils down to it, there was not a shred of evidence to the child's actual behavior during this case. Nothing, nowhere other than the grandfather's testimony that she behaved normal. There's no testimony
Grandfather's testimony was at a time prior to this injury, correct?
to the head injury, but per the testimony of the experts, the rib injury.
Like she had a rib fracture, she had kidney injuries, liver injuries,
Don't know the
abdominal
kidney, but the
injuries.
bowel injuries and the rib injuries were weeks or older, and they both testified that if she had those injuries, she would have been exhibiting nausea, possibly vomiting, fussiness, eating issues, and Grandpa said none of that. She was acting normal. Under the state's theory, Grandpa could be guilty in this case, because who's to say Grandpa didn't do this?
Was the jury entitled to consider the fact that the defendant apparently asked his brother to say the brother was taking care of the child during the critical time?
I think that's something, but that doesn't prove anything. That doesn't establish
It proves consciousness of guilt, doesn't it?
proves consciousness of guilt, but consciousness of guilt is not guilt beyond a reasonable doubt. You still need to prove that the defendant in some way did something. And simply saying, hey, you watched the child this day, doesn't say, I'm the one who abused the child. It could be
You add
covering
that
for
to the
Nicole
testimony-
Jean.
When you add that to the testimony of the defendant telling the baby's mother to shut the kid up, and I'm using polite language, and the brother's testimony that he saw the defendant slap the child or hit her, made him run laps, all the rest of that.
I would argue you can't consider Sean's testimony at all in those because that's
Because of
not
the
substantive
impeachment
testimony. That's impeachment. And impeachment cannot be used as substantive evidence, and that's point two, and that's why
The
that
defendant
testimony was
admitted
so
that he-
fundamental.
Defendant admitted that he tried to procure his brother to lie to the police, right?
I don't believe he testified in trial, but that was a statement there. And just
But he
lying to police,
testified
again,
Didn't your client testify in trial?
he did testify.
And didn't he explain why he asked his brother to lie to the police?
I don't recall entirely, it was to protect Nicole, I believe.
I think he
But-
just said that he was scared. The reason he did that is because he was scared or something.
And I think that's a normal reaction when you're being charged.
Isn't that something that the jury could have completely disregarded? You know, his self-serving assertion that he was scared, and
Absolutely,
that's
but
why
if you
had
look
him
at
do it.
that recorded conversation, what little you could understand, and you couldn't understand hardly anything, what is he doing? He's saying, they're trying to pin this on me. They're trying to get me to confess. I didn't do this. They're trying to get me to be guilty. So the whole time, even in that
So the
recording,
logical way to deal with that is to try to get somebody to lie for you to the police to
He could be protecting Nicole.
exculpate you, huh?
he could be protecting Nicole. Just like the Williams case recently in May out of the Supreme Court where they said two people have equal opportunity, equal motives to kill the victim. They said each person had an equal motive, and since it's based solely on circumstantial evidence, and the circumstantial evidence that exists isn't sufficient, Mr. Williams, who was on death row, is now walking the streets because someone else had an equal motive. Here we have the same thing, as the state below
What about
repeatedly
the
says.
text message, counsel? What do you say about that?
Simply saying, so what happened? Well, I came home and she's watching TV. That can mean anything.
Well, the question was pretty vague, how's it going, or how's
Yeah,
it going at home, right?
Yeah.
But the answer, though, suggested that that the query was although general, although phrased in a general way, that the query was about how is the little girl doing?
Well,
Because that's how he answered it.
when it comes down to it, we also have a situation where they have left the child home
Can't we
alone.
draw inferences from that with all of this other evidence that, you know, they knew during this period of time that this girl was suffering from some injuries and...
Well, I have two counters to that. First, what you're trying to do is stack inference upon inference upon inference to find the defendant guilty, and the law is clear. You can't find someone guilty based upon stacking of inference. Second of all, we also had testimony that they left the child home alone multiple occasions. It could simply be saying, so what's happening? Nothing. She was fine. I got home and she was just watching TV. It could be that he just took her to work and she wanted to know how the child was when he returned, and he said, she's fine. She's just watching TV. It has absolutely no context whatsoever. Furthermore, again, if the court was to believe the argument of the state that the injury occurred on July 9th, then all of Dr. Talleli's testimony has to be disbelieved. Because Dr. Talleli said this injury occurred within 24 hours. He testified this child would have been unconscious and or seizing immediately upon the injury. Thus, this child would have been seizing and unconscious for 2 days. There's no evidence to support that, though. Just as in Rodriguez versus Pino, these doctors are testifying based upon speculation and guesswork, and there's no actual evidence to support their testimony. As to the second point, and I want to just address Sean's testimony, the state in opening statement said, if he's consistent, this is what we expect, but we know he's going to recant. They didn't say he's not cooperative. They said recant. So they knew right away he was going to deny everything. He does testify, admittedly, to some things. All of it is cumulative. He testifies about the recorded conversation with his brother and says, but I don't remember any of that. That's already been admitted through the officer. The state spent their entire time reading his testimony into the record, even referring to it as sworn testimony. At one point, they might have referred to a deposition. It was a little unclear. Not only do they spend his entire direct cross-examining, using his prior statements as evidence, saying, you said this, that's the truth, that's the truth. They then get up in closing argument and say, well, you heard the testimony of Sean. That was the truth. His testimony, his sworn testimony to the officers, that was the truth. They not only use it to impeach him, and that was the sole purpose of calling him, but then they use it throughout closing to say, this is why you need to find the defendant guilty. This court in Fike found fundamental error in the use of Williams rule evidence that really didn't apply. The only difference between Fike and this case is preservation. Admittedly, none of this is objected to. Trial counsel lodged one objection during the entire trial. He just sat there quiet. But the facts remain. This witness was called for the sole purpose. They knew he was recanting. They knew the only witness that could put anything on Eric was his brother. Without Sean's testimony, they could not prove the manslaughter by act.
Didn't the neighbor also testify that on the day of the incident, or near the day of the incident, he heard a male and female voice arguing with the comment then, shut that damn kid up, and like that, the kid's quiet?
We don't know when that conversation happened. The neighbor is unclear as to who is in the conversation, so we don't know if it in fact was the defendant. And simply saying, shut the damn kid up, and the kid gets quiet, doesn't say that Eric is the one who did anything. It's equally possible that Nicole did something. So even when you take the neighbor's testimony, they don't say anything as to Eric doing anything. Everything in this trial was, this kid was really hurt, someone's guilty, we don't know who's guilty, so someone has to be guilty. We don't know who did this, but this was done, therefore he's guilty because he didn't get her help. But they didn't prove that had he gotten her help sooner, she would have survived. And without that, there's no manslaughter by culpable negligence. And I'd like to reserve the remainder of my time for rebuttal.
All right, sir, you've got a little less than 3 minutes.
Good morning, Your Honors, and may it please the Court. Marjorie Vincent Tripp, representing the state of Florida. Commenting on the last comment that my colleague made, that we didn't prove, the state didn't prove the timeline of these injuries. The defendant's own words in this case established the timeline, and the evidence established the timeline. With respect to the text message that was sent between the defendant, the appellant, and Nicole, the child's mother, that text message was sent on July 9th. If you look at that text message in conjunction with the fact that the defendant specifically asked his brother to lie and say that he babysat the child on the 9th and the 10th, the jury could have looked at that and said, you know, something happened either on the 9th or shortly before then, which is why the appellant is trying to establish an alibi, if you will, for what occurred to this child. And it also leads to the fact that the appellant knew that this child had been injured in some way and that it was serious enough that he needed to come up with some type of story to cover the fact that either this child was not supervised or to cover the fact that, or to establish that I didn't do this.
There's substantive evidence at trial on that point, though?
On which point, Your Honor?
Other than the impeachment evidence, where in the record is the substantive evidence?
The substantive evidence for the timeline?
Oh, that the defendant asked his brother to lie.
Well, the jury was able to listen to the recording that the brother had with Sean, or the appellant had with his brother Sean Jefferson. And admittedly, the recording was not clear in all parts of it, but they could clearly hear the defendant asking his brother to lie and say, hey, they're trying to pin this on me. We've got to come up with this story. You know that she fell before. You know that she had epilepsy. We found out this medical history. She could have had this epilepsy from a birth issue. So they could listen to the tone of voice that this appellant had when he was speaking to his brother. And he was really trying to convince the brother to come up with the story and to go along with it for whatever reason. So the jury clearly heard the context of the statements he made to the brother and the intonation in his voice and the fact that he was trying to really convince this brother to not talk to the police anymore, encouraging the brother to go see the same attorney, and the attorney would make it so that he wouldn't have to speak to the police anymore. So he was really, really trying to encourage his brother to, number one, lie to the police, which would ultimately implicate the brother in the crimes, because obviously, based on Sean Jefferson, or Eric Jefferson, these offenses occurred either on the 9th or the 10th or around that time frame. So there definitely was evidence that the jury could, tangible evidence that the jury could listen to and hear him asking his brother to lie. So that evidence absolutely was there.
The state required to prove that prompt medical care would have saved her life?
The state was required to prove that a reasonably prudent person would have obtained medical care for this child based on the severity of the injuries that she had and based on the symptoms that all the medical experts testified, not just Dr. Tillelli, they all testified consistently that this child, based on the brain injuries that she had and the abdominal injuries that she had, would have exhibited symptoms based from lethargy on the lower end to vomiting to nausea.
Testified that early intervention would have saved her.
Did they testify to that?
Did they render that opinion?
No, they didn't render that opinion. However, if you look at the timeline of, if we assume that the timeline occurred, the injuries were inflicted, the most recent injuries, which were the brain and the abdominal injuries, if we assume that those injuries occurred around the 9th, 911 was not called until the 11th, which was 2 days later. So there were at minimum 2 days that this child was exhibiting some type of injuries, according to all the medical experts, that were ignored by not only the mother, but by the
You're saying
appellant.
that that's within the province of a lay jury to be able to discern that if they find for the state on the alternative theory of liability, a delay or negligence in connection with procuring care for the child, can a jury determine that prompt intervention by the defendant would have resulted in the child not dying? Can they make that determination without an expert's opinion?
Well, the expert opinion was important to help the jury understand the injuries that this child had and understand the symptoms that she would have displayed. But, you know, the expert testimony combined with the other evidence that the state presented, the jury could have looked at that in totality and determined that this individual should have obtained medical care sooner for this child.
That's part of it, but the statute is a person who causes the death by culpable negligence. So causing the death means the state had to prove by delaying, if you accept the fact that the injury was on the 9th or 10th, delaying until the 11th to call, caused the child's death. What proof was there that the delay caused the child's death?
Well, the child is no longer with us. By the time she arrived at the hospital, the testimony was, the first hospital she arrived to, which I believe was in Leesburg, the testimony was that this child was severely critically injured. These were not injuries that were caused by accident.
We all understand that. We're not quibbling over that. But where is the testimony that said the delay in getting medical treatment caused the child's death? What witnesses gave testimony relevant to that?
There was no specific testimony on that point. However, the jury could have cumulatively looked at the evidence that these injuries occurred on or before the 9th. There was no evidence that there was any medical intervention for this child until the 11th. So they could have looked at that. And one of the cases cited in the...
Was that argument preserved?
No, and that was the other thing I was going to mention in addition to this case. There was no argument that the delay between the injuries that this child had and the eventual obtaining of medical services for this child was not proven. One of the cases cited, I believe, I might be mispronouncing, is the Postek case, and that was a case where the court found that because the state had not proven that the delay that the defendant had, which was about 45 minutes from the time the child was clearly injured to calling 911, the state hadn't proven that because it could not establish that the injuries, number one, were not obvious to the defendant. The child has some injuries internal, a brain injury that was not clearly obvious. And the defendant saw that the child was a little bit lethargic, put the child to bed, and it was only when that he couldn't rouse the child further and awaken the child that he called the mother and then was prepared to take the child to the hospital. So in that case, there was clearly a lack of evidence to prove that there was a delay, the defendant unreasonably delayed in obtaining medical services for the child. But this wasn't 45 minutes. This was clearly at least 2 days that the medical expert said this child would have been displaying injuries, more specifically severe injuries based on the brain injury that she suffered, or severe symptoms based on the brain injury that she suffered. So it's a clearly different case from the Postek case, and it was definite. Although there was not testimony to that, the jury could have said, yes, it was unreasonable that the defendant did not obtain medical services for this child, and based on his actions, he knew there was something wrong with the child, and ultimately the child is deceased.
What of appellant's argument that prosecution continuously said, we can't tell you which one did which injuries, but it's kind of like one of these two or both? How does he get convicted when the prosecution can't even say he did this act that caused this injury?
Well, the medical examiner testified that the most recent injuries that led to the death were the brain injuries and the abdominal injuries. However, the autopsy showed that this child also had a fractured rib that was healing. She had some, I believe, what they called fibrosis or scarring in her bowel that would have been injuries that were also healing. So the prosecutor was simply saying, in the scheme of all the injuries that have been demonstrated that this child suffered, we can't say for sure which injury occurred when or who caused that particular injury. But there was no implication by the prosecutor that, we can't say for certain or prove for certain that this individual caused the injuries that led to this child's death. But even if you don't exclude manslaughter by act, exclude the allegation that Sean Jefferson's impeachment was improper evidence because the prosecutor argued it was substantive evidence, even if you exclude all that from the equation, there was ample evidence under which the jury could have found this defendant guilty. The state's primary theory in this case was aggravated manslaughter of a child by culpable negligence. And the jury could have absolutely found that in this case.
What was the most powerful, most significant piece of evidence at trial that the defendant caused the injuries?
Well, in manslaughter by culpable negligence, we don't have to prove that the defendant actually caused the injuries. So that's why I'm arguing that even if you exclude Sean Jefferson's testimony or exclude any proof or are unable to prove that this defendant actually caused the injuries to this child, there's still sufficient evidence to find him guilty. You have the child's injuries. We can show that there was a timeline when those injuries occurred. He clearly established that he left this child unsupervised on the 9th and the 10th and for a period on the 11th, while this child was obviously injured at home and by herself. And again, this is a 3-year-old child who could not take care of herself. There was also testimony that was inconsistent with what the defendant initially told police. He initially said that, my brother or my girlfriend and I are the ones who are the sole caregivers for this child, but then the story changed later on when he asked his brother to lie and said, my brother was actually watching this child on the 9th and the 10th. We also have the evidence of, the jury saw the pictures of the apartment. They saw that there was nothing in the apartment, according to the medical examiner's testimony and the other testimony, that could account for this child's injuries. They also saw the photograph of the hallway leading into the bedroom, and there's a large dresser leading into that hallway. The CSI who took the photographs said that it was very difficult to maneuver around that dresser. And if his story was that he was in the kitchen or he was in his bedroom and he heard a thump, which could have been show that he knew exactly how this child was injured. If his testimony was that he heard this noise, went into the bedroom, and found this child laying there, if it was difficult for the CSI to go into the bedroom, then how was it that he was able to take this child and carry her from the bedroom into the living room where she was eventually found? So there were a lot of inconsistencies with the story that he gave to the police, and based on the evidence that was presented, the defendant's own words that the jury heard on the recording, and his implausible testimony that he gave in court, the jury clearly could have found this defendant guilty under the theory of manslaughter by culpable negligence.
What evidence establishes the timing of the injuries?
The timing of the injuries, all the medical experts they couldn't pinpoint exactly when the injuries occurred. The medical examiner testified that the brain injuries that the child had, as well as her abdominal injuries, the more serious injuries, were the most recent, or as some of them testified to, were the fresh injuries that led to this child's death. No one could actually for certain say when these injuries occurred because there was no testimony as to how they were inflicted on this child to begin with. They could tell that some of the injuries were healing, which meant they could have been a week to even more weeks old. For example, the rib fracture and the fibrosis in the bowel. But they could clearly see that the more recent injuries that were still bleeding and were not healing were injuries that could have occurred within days or within that week.
Is there any evidence that the injuries occurred while the child was left alone?
There was no evidence to that, and in fact, all the medical experts were consistent that, let's assume the child was left alone, they were consistent that this child could not have obtained those injuries by jumping from the dresser that was in the room. She could not have obtained those injuries by falling down the stairs, which the jury saw the photograph as well. So they were all consistent that these were blunt trauma injuries that were inflicted. And they even said the abdominal injuries that she had were injuries that were caused by an intrusion into her abdomen. There was no car accident that was consistent with these injuries, and some of the injuries were whiplash-type injuries. None of the defendants said that the child was in good health. The grandparents said prior to this the child was in good health. So there was nothing else but for blunt force trauma and acceleration or deceleration type.
How does that evidence establish the culpable element of the crime? You said that the defendant didn't need to actually inflict the injuries. How does this evidence get you to a proper verdict?
Well, all the evidence leads and points to the conclusion and supports the conclusion that this defendant was aware that this child was injured.
That relates to the neglect, correct?
Correct. And the neglect in failing to obtain medical services for this child in order to maintain her well-being, knowing that she was injured. And that was specifically what the state argued, was that he failed to provide the supervision and, more importantly, obtain the medical services that she needed to maintain her health, which ultimately led to her death.
How did lack of supervision, though, lead to the injuries?
Well, it's not just the supervision. It's a combination of the lack of supervision as well as the failure to provide medical care. Obviously, this child was severely injured because she ultimately died from her injuries. You know, a reasonably prudent person would not have left a 3-year-old at home on the 9th for at least 5 hours, on the 10th for at least 5 hours, and on the 11th, I believe, for at least a 1-hour period while she was in this type of condition without obtaining, in addition, medical care for this child.
But aren't those two separate issues?
They are two separate issues, but the jury could have found under either theory of lack of supervision and or the lack of obtaining medical services for this child. She was neglected in that respect. The defendant neglected her by providing this for her, and ultimately that was the reason that he was found guilty. So unless the court has any additional questions, we would rely on our answer brief and ask this court to affirm. Thank you.
All right, thank you. A little less than 3 minutes, sir.
Thank you. The only difference between the instant case and Positek is that the child died. What we're lacking in this case is several things. We don't know who caused the injury. No matter how much they want to emphasize the injuries, we don't know when the injuries occurred. We don't know where they occurred, how they occurred, what caused them. We don't know anything about these injuries other than they exist. And as the court has asked repeatedly and still hasn't gotten an answer from the state on is, there's no evidence that this child would have survived had the help been
How was
gotten
that
sooner.
preserved in the record below?
I admit it is not, Your Honor. I admit trial counsel did not argue that it is JOA. However, under FB and Tibbs, that represents fundamental error, where the state fails to establish that a crime occurred.
You know, in fairness to the state, had that been argued as a basis for the JOA, and the state would have had the opportunity to ask the court to reopen the evidence.
It's very possible.
So
but under every fundamental
you can't get them
error,
where they got you. I mean, you know.
under every fundamental error, as in FB, or the more recent case of Monroe, where the court found
We don't know that one
ineffective
of these
assistance.
state's doctors didn't have the opinion, was not of the opinion, that there was a causal connection between the delay and
I find
bringing
that-
the child to the hospital, and we don't know that the state couldn't have
When you look
offered
at the
that.
evidence in this case and how much, as the state just did again, and stressed the severity of the injuries, I think it would be extremely hard to believe that a doctor would say that this brain injury could have been survivable had she gotten help earlier. And again, we
If
still...
they didn't think the brain injury was treatable, they wouldn't have performed brain surgery, would they?
I think they would, I don't agree with that. I think a doctor, when given a child that's injured, is going to do everything they can to try to help that child survive. Whether they can survive or not, that's the Hippocratic, I mean, they're going to try to do that. They're going to try to save a life. I don't think the fact that they gave treatment means that this child could have survived. I think they tried to help the child, and look, you can give treatment in hopes that the
was
child survives, and this child still doesn't
The fatal
survive.
condition or fatal injury, at least in part due to the fact that the brain continued to swell post-injury?
We don't know that. That's the state's failing of the evidence. We don't know any of this. The state's response, it's the
You're not
state's
saying,
burden.
you're saying there was no testimony as to that was part of the cause of the injury?
There is no testimony that the continued swelling is what caused the death. Now, there was continued swelling, and she died as a result of the brain injury and the swelling. But there's no testimony that that continued swelling was preventable. When you look at the testimony, they gave her special drugs by the EMT to try to get her to stop. They went in, gave her more drugs at the first hospital. Then they did surgery to reduce the swelling, and the swelling was not stopping. So no matter what medical intervention they gave, that swelling continued. There's no testimony
Answering your
that the
question,
delay
'cause
in
he's
his
over
getting
time. You're
help
over time,
caused
sir.
it.
You're over
I'd
time.
ask that
Thank you.
this court reverse and remand for vacation.
All right.
Thank you.